Good evening, everybody. Welcome to Dingley Marshall's 5th webinar. We are a group of 4 tonight. I think this is the most that we've had, presenting on the Alert Level 3 regulations. Tonight, it will be myself, Lucien Lewin. I'm a director at Dingley Marshall, and I'll be assisted by 3 of our associates, Matthew Thomson, Peter Turner, and Megan Scott. Today, we'll each be spending about 10 minutes on a specific aspect of the regulations. And we would invite you to please send in your questions that you may have on what we're discussing, or maybe any other aspect of COVID-19 which you'd like us to chat about. We may not be expressly speaking about it, but maybe we can help you tonight as well. So what I'd like to maybe just start off advising you of is what we're going to be dealing with. So I'll be introducing first. I'll be talking about the amendments in general and their effect on previous regulations issued. We'll be talking about the hotspots which have been identified and what the circumstances around identifying a hotspot in the future will be looked at. I'm going to talk about movement of persons under level 3, who's allowed to move, where you're allowed to move, etc., etc. And then finally, I'll be talking about the operation of the economic and public sectors under alert level 3. Megan will follow on. She'll be talking about prohibitions on evictions during level 3, which is quite an interesting topic, I think. There's a lot of debate going on about that outside, and especially in regard to informal settlements and homeless people and those kinds of things. She'll also be looking at the status of gatherings under alert level 3. What is permitted, what is prohibited, what are the offences or penalties for being involved in a gathering that's prohibited. And she'll also be dealing with places and premises which remain closed to the public under alert level 3. Peter will be talking about that hot topic, sale, dispensing, or transportation of liquor. I think there are a lot of people who are very relieved about the 1st of June coming and that liquor stores open. Yeah, well, and other than those who've been waiting in queues for hours. And then he'll also be talking about tobacco products, e-cigarettes, and related products under these regulations. And finally, he'll be talking about compliance officers who are required to be appointed in both public and private enterprises under alert level 3. Matthew's got the really juicy one. He'll be talking about controversial legal challenges which have been raised in respect of the regulations. We think this is going to be a very hot topic, and yeah, I'd like to reiterate that you please send us questions. We'll try and answer those questions while we're speaking, or if maybe not appropriate, then we'll leave them to the end of the seminar. So if I may kick off, guys, I'd like to chat about these regulations and what these regulations mean from a sort of perspective. Firstly, aside from Regulation 3 of these regulations, which were published on Thursday, Regulation 3 amends the original Regulation 3 as set out in Alert Level 4. These regulations actually add to the regulations published on 29 in respect of alert level 4. So you've got alert level 4, which was published on the 29th of April, I think it was. And those regulations, aside from Regulation 3, and they still apply even though we've got these new regulations right now. But the interesting thing here is that alert level 4, actually, which was published, as I said, in April, repeals the lockdown regulations which deal with alert level 5. Now, as we are all aware, the President made quite clear that there's a possibility that certain places, hotspots for lack of a better word, may move up back to level 4 while the rest of the country goes down to level 3 or level 2. If we are, let's say Cape Town gets put back up to level 5, we actually have a very interesting situation where there are no regulations dealing with alert level 5. So we'll have to watch the space very carefully to see what happens. So moving on, another interesting fact is that previously, the regulation specified what businesses or economic hubs were allowed. So if your business or economic hub was specifically included, such sector was allowed under level 4 and level 5. Now, if your business is expressly mentioned in the current regulations, the likelihood is that such business is excluded from operating. this seems to demonstrate the leaning from the government to opening the economy rather than closing it. It was easier in the beginning to say, well, these who are not allowed to operate because there were so few of them. So few of them were allowed to operate, sorry. So they mention in the regulations are those businesses or economic hubs which are not allowed to operate. Regulation 3, as I said earlier, of the 29 April regs have been completely amended to allow for specific rules to apply to provinces, metros, and districts. This is in line with the President's address advising that various geographical areas may find themselves operating under different alert levels at the same time. In this regard, Regulation 3 of previous regs is amended as follows. Firstly, movement of persons may be restricted in and out of designated hotspots. So if you've got certain hotspots which have been set out in the regulations, places like Cape Town, places like Durban, I think that's eThekwini, Ekurhuleni, Pretoria, Tshwane, these are all hotspots, and they are, in terms of these regulations, the executive has reserved their rights to prevent certain hotspots from letting people come into or leave them. So that's quite an important change in terms of, specifically in respect of Regulation 3. And it also says that the health minister has an obligation to identify a hotspot in consultation with the provincial health MEC. And when she does this, or when he does this with the provincial health MEC, he has to take into account the number of active cases per 100,000 population, rate of increase of active cases, the availability of hospital beds and related resources, and any other factor relevant for purposes of containing COVID-19. That particular one, I think, gives the executive a discretion to open up it opens up a discretion for the executive to include further factors should they want to do so. Furthermore, management of the hotspots includes the formulation of a plan, the formulation of this plan being overseen by the health minister. This plan is to be formulated in consultation with the health MEC in the relevant province. So if the health minister says, listen, we've identified Cape Town as a hotspot, then he needs to consult with the health MEC about the city of Cape Town, and they need to put together a plan which would include surveillance and intervention measures. It includes increased deployment of personnel, increased testing, managed quarantine and isolation sites, and increased resources, health services. One of the issues Matthew actually raised with me earlier when we were discussing this was the testing in certain hotspots. So there's an argument that's being made that the reason we have so many cases in the Western Cape, and specifically in Cape Town, is because the testing is so much better. And it's a lot more efficient than elsewhere in the country, and that would spike our numbers. So one wonders whether the executive is actually going to take that into account when they assess whether Cape Town is a hotspot. Although, Matthew, it just strikes me now that another issue is the deaths. I mean, you can look at deaths. Deaths, you don't need stats to say whether someone's died or not. If you can say, well, these people have died from COVID-19, that should be an indicator for government when they are looking at declaring a hotspot.
Yeah, so I think, obviously government's dealing with sort of practical difficulties with regard to the disease and the testing and the deaths, but I think I would have liked to have seen a more specific reference to testing as being a factor to consider in subsection 4. I also would have liked to see something like the rate of recovery as opposed to just rate of increase in active cases and cases per 100,000. I don't think that, my personal view is that I don't think that those are very effective metrics to track where and how a hotspot should be dealt with. So I think, fortunately, there's the catch-all in subsection 4D, which deals with any other factor relevant. So yeah, I suppose government might well include such factors as rate of recovery and testing under that subsection. So let's see how it works out.
Yeah, yeah. So I'd like to move on to Regulation 33, which actually deals with the movement of persons under level 3. So the default position in terms of the regs is you've got to stay at home. You cannot go running out. You can't, if it's not listed in the regulations as being allowed, then you have to stay at home. So, for example, one of the things that it doesn't allow is, it doesn't say you're allowed to go down the road to your friend and have a beer with him because you haven't seen him for ages. That is not specifically allowed under Regulation 33, and therefore you can't do that. So what they say is a person may leave his or her place of residence to do the following. They may want to perform any service permitted under Alert Level 3. As stated earlier, services permitted are those not expressly excluded in terms of these regulations. You're allowed to travel to and from work under Regulation 33. You're allowed to buy goods, travel to buy goods or obtain services, except those excluded under Level 3. And then you're allowed to move children as allowed. So that would probably include things like taking your kids to school. If your children don't take public transport, you are allowed, you won't be found foul of the law if you're taking your children to the neighborhood, to the school. You may have to cross district lines in order to do so. In fact, one of the things that I've noticed about the regulations is that they also say that if you do cross district or municipal lines, you actually have to have a permit from your school, from the school principal, allowing you or permitting you to do that. Then the other thing, the big point of contention, bone of contention, is exercise. And interestingly enough, you're allowed to exercise between 6 a.m. and 6 p.m. And exercise isn't defined as it was defined in the previous alert level regulations, where it said exercise was limited to running, walking, and cycling. So provided that your exercise is not done in organized groups and adheres to social distancing measures and protocols, you're entitled to exercise anytime between 6 and 6. Your surfers may say, "Whoa, this is great. It's not limited to walking, running, or cycling. I can go and surf." Yes, if you can surf without walking on the beach, unfortunately, because beaches are still closed. So somehow, if you can get a helicopter to drop you in the middle of the ocean, you'd be fine with the law. I think, Megan, you're going to deal with that at a later stage, dealing with what places are open. So I won't rain on your parade there. And of course, the other big one is your ability to attend a place of worship anywhere in the province. You're not limited to staying within your district or even your municipality. So that's quite an interesting one, where they seem to allow you to go to church, which is not limited to the immediate area in which you are, or mosque, or wherever it may be. And then, of course, you're entitled to attend a school or learning institution once opened. As we all know, that was supposed to be open today, and it's not happening. Mask wearing in public is compulsory. You've got to remember that, specifically when using public transport or in a public building. This would include exercising in the public space. Must you wear your mask while driving your car? Debatable. One would think that if you look at the logic behind the law, it shouldn't, if you're alone in your car, you shouldn't be requested to or required to wear a mask. On a strict reading of the law, if you're driving your car in a public space, well, you're in public and therefore you must wear your mask. Who knows how they're going to enforce that in the future. Movement between provinces, metros, districts, and in and out of hotspots is prohibited, except for people traveling for work, moving to a new place of residence, members of parliament performing oversight responsibilities, learners or students having to commute to and from school, and attendance of funerals. I think, Peter, did you have something you wanted to ask me about this? Did I see a message coming from you? No, sorry, my apologies. So we've got that, and then we're also dealing with medical treatment as well. You're allowed to cross borders for that, and of course you're allowed to cross borders to return to a place of residence, or if you are, returning to a place of residence after having been quarantined or been in an isolation facility. I noticed that my time is up, and I haven't dealt with operation of economic and public sectors, which is quite important, but let me quickly do it if I can do like 30 seconds, guys. So firstly,
we've also had 1 or 2 questions come through on that particular issue, Lucien, so maybe deal with that, and then I will read you the questions posed, and then we can deal with it that way.
Excellent.
I'm just going to drop the questions under the webinar chat as well for everyone.
Okay, great stuff. So basically, the businesses which are listed in Table 2 of Annex A to the regulations are not to operate under Level 3. Like I said earlier, you've got to, if you're listed if your business is listed there, you're not allowed to do it. These include restaurants, bars, and shebeens, short-term letting for leisure purposes, domestic passenger air travel for leisure purposes. So the implication of that is domestic travel for business and short-term letting for business is permitted. So if I'm going to port in Johannesburg tomorrow, I can go and book an Airbnb or go into a hotel to stay there, provided is because I'm doing business, and I can, of course, take a plane to Johannesburg to be in port. Notable exclusions from Table 2, which therefore are arguably allowed, are that gardeners and domestic workers aren't expressly excluded. So your domestic worker could come to work, or your gardener can come to work, but there are certain protocols which have to stay in place. I'm going to stop there because I think I'm really running out of time. Are there questions which I should deal with right now?
Yeah, Lucien, there's a few. Yeah, I see a few that I think should be dealt with. So we have a question from Pila Zulu, and he asks, I've posted this question to the webinar chat, but he asks, are permits still relevant under Level 3, considering that pretty much all industries, barring a few, are allowed to return to work?
Thanks for the question, Pila. The permit issue comes into play, particularly when you're crossing district and municipal lines. So where, for example, I'm employed in, let's say, on the West Coast, and I live in the southern suburbs, I'm going to have to move from one district to another, from the city of Cape Town, which is also, I believe, is a district as well as a municipality, to the West Coast district. And I would then need the head of my institution to say I'm an employee of that institution, and that I am required to travel across district lines in order to get to work. So that is when permits will be required going forward. It's the same with funerals. When you're traveling over district or provincial lines to attend funerals, it would apply to all of those kinds of things.
Okay, great.
Is that it?
We have 2 questions that have come through from Mr. Ken McKenzie, and also one from Cyril Chetty. I think these questions will fall broadly under Megan's topic, so perhaps we can just hold those questions for now. We will get to them later. Lucien, I think you've essentially answered this question, but there was a second follow-up to that question. That was that just dealing with travel in between districts, provinces, metro districts, and hotspots. I just wanted to just remark on that. There has not yet been any declaration on what happens specifically with regard to travel in between hotspots, travel in and out of those hotspots. So I think we'll have to wait a little bit to see further directions from the Minister of Health, and they'll have to come from the Minister of Health. I think we can move on to our next section. As I said, Megan can address the other 2 questions a little bit later.
Yeah, that's perfect. Okay, cool. So my things just that I'm going to run through is the places and premises that are closed to the public. And then, as Lucien said, I'm going to deal with evictions generally and gatherings. So in terms of Regulation 39, generally most of the places that were closed under alert level 4 remain closed for the most part. There's few amendments that are worth mentioning is sports grounds and sports fields and swimming pool. So swimming pools remain closed to everyone except for training of professional athletes and professional non-contact sport matches. which is a new amendment that's been brought in under alert level 3. And then that has come into the allowance under regulation 37, which is a professional non-contact sport match, which may only include players, match officials, journalists, medical and television crews. So now that's being allowed under alert level 3. Other places that are still remain closed, which I think some people expected parks and beaches to open, as Lucien said, beaches remain closed under alert level 3. And then public parks also remain closed under alert level 3. The Sandparks website has released some notes or an announcement to everyone, which I'm sure some people have read. But for those of you who haven't, they said that only open access national parks, so namely Golden Gate Highlands, parts of the Garden Route and Table Mountain National Park, with the exception of Boulders Beach and Cape Point, will be allowed access to visitors from 1 June. Further regulations and stuff will be released from the Minister of Environment, Forestry and Fisheries regarding the opening of other parks. Yeah.
Can I just ask a quick question, Megan? So,
yeah.
So there's one question that we've got in, which says, does a rocky shore qualify as a beach? Which is quite an interesting question, because I think this person is wanting to go surfing, but he wants to surf from the rocks rather than from the beach. The letter of the law, who knows? Probably not. But the spirit of law probably would say that it does form part of the beach. I think that what that question does illustrate is that these regulations aren't really the clearest form of legislation that we've ever seen. Understandably, this is the first time that we've had a pandemic to have hit the world like it has, closing us all down. So I think lots will come up in litigation going forward, if there's litigation on these kinds of things, including terms like what is a beach? Is a beach sand, or is a beach rock, or is it both, etc., etc. One of my other questions, though, that I wanted to ask you is and I think it's a huge topic of debate, is the issue around parks being closed, and beaches being closed, where you have people who are allowed to exercise between 6 and 6 every day. Why close a beach? If you're allowed to exercise, you can get so much open air on a beach. A beach is huge. It's not like it's a confined space. What is the legitimate purpose behind closing beaches? It does seem a little strange to me. I don't know what the rest of you think.
Yeah, I mean, I think a lot of these regulations are going to be or remain controversial, and a lot of people are going to have their opinions stuff because they worded so broadly, vaguely. There's no real reasons around them, so I think we can sit and debate them for a while. But I think it is a valid point that some of them do seem a bit arbitrary, and in a way contradict each other, as you say, Lucien.
Maybe if I can just add to that, one of the interesting amendments, or one of the amendments that I took a personal interest in, is that under alert level 4, the type of exercise that was allowed between 6 and 9. So we've seen two things. Number one, the time period has been extended from 6 a.m. to 9 a.m. to now 6 a.m. to 6 p.m. And there's been a critical, I suppose, an omission in the alert level 3 regulations, in that it doesn't limit us to running, walking and cycling, which was previously the case. So I think some of you would have seen the protests around surfing and paddling. It now appears that if the activity which you wish to do can be categorized or defined as exercise, then under the new alert level 3 regulations, that exercise will be allowed, because the wording of 33(1)(e) is specifically exercise between the hours of. Now, I don't know, obviously these regulations, and given the time period that they are given to publish and to draft, as Lucien said, are not a picture of clarity. But we've seen already, just from today, I know that police and enforcement officers, for example, are allowing people to surf at certain beaches. So I don't know whether a directive has been given to them as to how to enforce that, but I think the surfers would be in with a shout of an argument to say that surfing is an exercise, and therefore they are permitted to surf under 33(1)(e). I think Lucien is smiling because of what we joked about earlier, in that even if you are allowed to surf under 33(1)(e), presumably you're not going to be in the water at the start of the regulation. So how exactly do you get into the water without accessing a beach? I don't know, perhaps that's anonymous attendees sort of question as asking whether a rocky point is a beach. But for now, it looks like enforcement officers aren't taking that line too strictly.
Yeah, and I mean, just to add to that, the problem with the regulations and definitions and these types of documents that are vague and leave it open to interpretation, it's not simply as to how we as the general public would interpret those regulations, but how the individuals who enforce those laws interpret those regulations. I mean, as you just mentioned, that you may have some enforcement officers that are quite happy to allow surfers to cross the beach to get to the water, but it very much depends on what type of person and what type of enforcement official you could be dealing with on the day. You may have someone who just does not believe that is allowed, and if we as the public have issues interpreting the regulations properly, it could get very hairy when those who are, delegated the function of enforcing those regulations are also unclear as to what they can and what they shouldn't be enforcing.
Yeah.
Megan, do you want to move on to the prohibition on evictions? I think that's quite an interesting one that we should maybe just...
I think there was a question asked about can you stay in...
Will there be accommodation for
business travel? For business travel. So in terms of the regulation, this is quickly and then I'll move on to evictions. But so hotels, lodges, bed and breakfasts and stuff like that, so timeshare facilities, resorts, they must stay close to the public. There is an exception though for remaining tourists, and then it says persons for work purposes and persons in quarantine and isolation. So because you can travel for business purposes, you will be able to stay in hotels, lodges, bed and breakfasts, and for work purposes. So just to answer that quick question from...
Yeah, that's exactly right.
And then actually also an interesting point, just to wrap that bit up, is it's actually under the regulations, it's strictly an offence. You're committing an offence if you stay in a hotel, bed and breakfast, lodge, or any place like that during the time of the lockdown. So it's actually quite an interesting, it's expressly included in the contravention clause. So yeah, that's just quite an interesting thing to point out. And then to move into evictions smoothly. So during alert level 4, they said that you could get the court order, but you couldn't enforce it until the last day of the alert level 4 period. When the alert level 3 regulations came out, now that seems to be exactly the same, except it says until the last day of alert level 3. So it's slightly arbitrary as to why that's extended now for another alert level, but it expressly says now, so the position now is a court may grant the order, but will order a stay or suspension of the order until the last day of alert level 3, unless it is argued or reasoned that it is not just or equitable to do so. So that's really, and then we don't have any court directives yet because they're quite, the regulations are quite new. So in terms of the processes and stuff going forward, actually getting your maths on the roll and stuff, that'll all soon to be seen. And then my last point to talk about is just gatherings in general. Still pretty much the same.
Sorry, Megan, can I?
Yeah.
Sorry, Megan, just on that point as well, an interesting issue on the prohibition on eviction is what classifies a home from which you can be evicted. So there's been a lot of news on people in informal settlements, for example, who are being evicted, and the argument against that is, well, the argument for those evictions is that this doesn't constitute a home, which is quite an interesting spin on it. So you have municipalities trying to enforce those evictions on the basis that those are not really homes, which I think sort of raises a constitutional issue as well. But it's just an interesting thing to consider. And then homeless people as well. You know, where a homeless person sleeps in the gardens and has his things around him, so cardboard, makeshift structures, which to find some sort of shelter. And they say, well, then the argument could be, well, that's not a home. It's a shelter. In fact, the argument has been made that is litter. We can move you out, and it's not an eviction, so we can do it. Which raises again a whole lot of constitutional issues. Anyway, I just wanted to sort of flag that.
And also, if I recall correctly, if you're looking at evictions in terms of the PI Act, you were looking at a definition of a dwelling and not a home. So I would think, to my mind, that protection is afforded to those individuals, and that the state is maybe trying to get around one or two legal restrictions which they shouldn't be. So,
so there is a fantastic judgment that I know Lucy and I have dealt with in the we've been part of a few matters involving the homeless persons in Cape Town, and there's a judgment in the Supreme Court of Appeal. It's Ngumani and others versus City of Johannesburg. And it essentially dealt with the distinction of land that is capable of being occupied for the purpose of the PI Act. So the argument went that if it's land and you can occupy it, then you must evict in terms of PI. If it's not land and you can't occupy for the purpose of PI, then it's not required that the city or whoever the evicting authority is complies with the provisions of PI. That case dealt very briefly with persons residing on essentially traffic islands. And if I recall correctly, and Lucien, please do correct me, the court found in that matter that you could not occupy traffic islands for the purpose of PI. Obviously, in the cases that we've been dealing with more recently, if it's land, if you can erect a home with any sort of permanence, tents and that sort of thing, where people are actually living and cooking and sleeping, etc., then it sort of pushes you towards land. It's an interesting judgment if you're interested in this type of law, and I think if you Google it, you'll come up with some very helpful results. I also think Lucien can speak on this topic a lot more than I can because of his recent involvement in the homeless cases.
You did a good job there, Matthew. Well done.
Thank you.
If you want to answer the question about staying in, there was a question about moving. If you now have to move and your lease ends up and you've got to go to your new place of residence. So in terms of the regulations, it does allow for people to travel for the purpose of moving to a new place of residence, and you will need to just be in the possession of an affidavit, and that affidavit, it corresponds with Form 6 of Annex A. So if you go to Form 6, it will just be an affidavit that you are moving, you have a lease, you where you're going, all of that stuff. So you'll just have to conform with those regulations. I don't know if anyone else has anything to add for that.
Yeah. I am very mindful of time, guys. This is really interesting.
I'm not trying to quickly answer.
We're running out of time.
Okay.
I think
mine will be short.
Megan, is there anything else that you think is quite important for us to say in 30 seconds, or can we move on to Peter?
I'm trying to read the questions while. So Peter, do you want to go, and then I can always go back and answer.
In fact, if Peter can start, and you can actually type the answers back and make sure that it can be seen by everybody else. That would be awesome. Cool, Peter, go ahead.
So I have been asked to deal with the fun stuff. I'm dealing with the current tobacco, the sale and transportation of tobacco products, also the newly lifted ban on the sale and distribution of liquor products, as well as the slightly more boring issue of compliance officers in the workplace. So the short answer to the current sale and distribution of tobacco products is a definite and bolded and italicized no in the regulations, unfortunately for all of us who happen to be smokers. So unfortunately, it seems like those who are partaking in the leisurely activity of smoking have to wait until level 1, probably, if the Minister of Cooperative Government's comments or anything to go by. So for now, unfortunately, your nicotine fix will have to wait. But there are currently 2 high-profile legal challenges to the regulations that have been brought on the basis of the tobacco ban and its constitutionality or not. Those have been brought firstly by the Free Trade Independent Tobacco Organization or Association, FITA. That one has been ongoing for slightly longer than the other one, and I think we have touched on the FITA challenge previously. A slight update on that matter, and I may overlap slightly with Matthew here. Nothing much has happened. I believe that the government has responded to FITA's initial application papers by delivering their answer, which constitutes about 4,000 pages, if I read correctly earlier today. So it seems like FITA's attorneys will have their work cut out for them, going through all of those bits of evidence and annexures and providing their reply. So we hope that that matter will be in court either later this week or early next week for argument, after which we will have a decision. I have also read earlier this week that British American Tobacco South Africa, or BATSA, have reignited their legal challenge to the constitutionality of the regulations after previously deciding to let that particular matter lie in order to compromise or discuss the issues surrounding the sale of tobacco products further with government. It seems like a statement was released earlier this week by which BATSA confirmed that government was either not willing to play ball or did not respond to their various calls for participation in the decision-making process with regards to the tobacco products ban. And they will now also be pursuing their own legal action. Similarly, I would think, to the grounds on which CETA have based their challenge. So watch this space. We will see what happens with that particular challenge. But if I understand correctly, that particular matter is still in its infancy. So getting back to the sale and distribution of liquor products, I think if anyone around the country was asked what the level 3 regulations mean to them over the last week, that is the first thing they probably would have highlighted, the fact that they are now able to buy their gin and tonics and beers and whatever the case may be again and enjoy a glass of wine with their dinner. So the regulations, very interestingly, and I think this is at regulation 44, now allows the sale of liquor. And it's quite interesting if one looks at the entities or the bodies that are entitled to sell liquor and alcohol. So the regulations provide for sale of liquor products by both entities who have a on-site consumption license, as well as those that have an off-site consumption license. So that means that entities like your local bar, your local hangouts, that was normally only entitled to sell alcohol for on-site consumption, can now sell you your six-pack or your bottles of beer, provided that you consume those off the premises, which is very convenient. And it also saves you the trouble of having to stand in 2-3 hour queues at your local spa, top, or whatever the case may be. These entities are also entitled to only sell these products between the hours of 9 and 5 on Mondays through Thursdays. So no alcohol may be sold on Fridays, Saturdays, and Sundays, and also no alcohol can be sold before the hours of 9 a.m. and after the hours of 5 a.m. between Monday and Thursday, very interestingly. Also, the distribution of liquor, and I'm sure this was done mainly to ensure that we could all approach a liquor store today and buy our preferred tipple, were entitled to commence with distribution proceedings on
29th of May. Oh,
yeah, that's correct.
I think we've lost Peter. Yeah, so I think that was, if I can just take over from Peter there until we get him back. Basically, that was, I think, an attempt to make sure that people can prepare for today when liquor stores were opening. The other issue which I think Peter was going to deal with were the tobacco products, e-cigarettes and related products. These are still, obviously, we all know it's prohibited, and funnily enough, the government is still allowed to export cigarettes. So again, there's no, I think I mentioned this in the last webinar, they're not sort of stopping the supply of cigarettes and tobacco products, but actually the smoking of it, the act of smoking. So they're not saying, well, because we're opening up the supply chain, more people can be exposed to COVID-19. They're actually saying, well, if you smoke, it's going to make COVID-19 worse for us. Which is interesting because as people have pointed out, this is not what the rest of the world believes when one looks at the way that the rest of the world has dealt with cigarettes. So that may still be challenged. Peter, are you back?
Sorry, I'm there. I must apologize. Sorry, my Zoom system kicked me out of the program for some reason.
I've just quickly finished off with the liquor thing, and I've done the tobacco. Can you just quickly tell us about compliance officers?
Okay, so luckily there's nothing too much new to add on the compliance officer issue, as the regulations stay quite similar to what they were under level 4. So as Lucien mentioned earlier, any private or public business or enterprise that is continuing their trading or running a business during level 3 has to ensure that they have a compliance officer appointed, and that compliance officer is responsible for the drawing up of what is called a phased-in plan, which is a plan which determines how a particular workplace plans on having its employees return to work. Obviously, we can't, most major businesses can't have all 300 of their employees rocking up to work at the same time, because that would completely fly in the face of the various social distancing provisions and the various health and safety regulations and directives that have been published over the last couple of weeks. So that particular compliance officer needs to be appointed. They need to assist in drawing up that phasing in plan, and that particular plan needs to be created. A physical document needs to be created and needs to be kept at any particular workplace, so that they can be inspected if the big bad labor inspector just happens to attend your business on that particular day. So that document, this compliance phased-in plan, needs to set out a few basic requirements, and they're all very easy to understand. They need to set out the identity of the compliance officer and his or her details. They need to set out the number of the employees who will be returning to work and the staggered phases in terms of which those employees would be returning to work. Those particular employees' details need to be captured and set out in the plan. Then the plan also needs to set out the various health and safety requirements or precautions that particular workplace has taken. That is obviously to ensure that particular phase-in plan complies with a whole host of health and safety regulations that have been published over the last couple of weeks to prevent the spread of the virus. So that's really all that needs to be in that document. Yeah. Obviously, entities that run a type of business where you will have hundreds of attendees on your premises every day. So, for example, retail stores need to take it one step further. So their social distancing measure takes on a bit of a different flavor, because you need to ensure that there's 1.5 meters between you and the next person in the queue, how long that queue may be going on for, and then also every single...
Peter, sorry, I'm aware that we were running out of time. So I would like us to go on to Matthew. So if I can give you another 15 seconds.
Sure, cutting me short, eh?
Yeah.
So I mean, if your business is a big retail store where you're dealing with hundreds of visitors a day, you will also be required to have the name and details of your compliance officer posted somewhere in the shop or in the particular premises where it is easily accessible and easily visible to those who visit those particular premises.
Right. So I think what I get out from what you're saying, Peter, if I can just close it off, is that the compliance officer is quite an important person. It's quite a responsibility to be a compliance officer. And you must therefore be careful of snollygosters, which are shrewd and unprincipled persons, I've been told. They're often associated with politicians. Right. Yeah, so just be very careful. Okay, moving on. Matthew, can you tell us about controversial legal challenges which have been raised in respect of the regulations? Probably not just regulation alert level 3, but also we're talking about alert level 4 and 5 as well.
Yeah, I'm certainly not going to be able to use the type of language that Lucien's been using, and snollygosters, unfortunately, beyond my vocabulary. But yeah, I think Peter said that he was given the fun section, and that's something that I thought I'd been given, the challenges. I think, we've got 15 minutes. A lot of these challenges I've read the founding papers of, and they sort of range in from sort of 100 to 355 pages. So I'm going to go quite swiftly and briefly through the challenges, and then just perhaps focus on the 2 or 3 that I think really sort of have legs. Maybe to start on sort of more of an entertaining note, we saw recently, last week, that an independent advocate brought a review proceedings relating specifically to hairdressers and their ability to trade during this time. I say entertaining because I recall that at paragraph 80 of the founding papers, there's a wonderful poem included about what exactly hair means to people. And I don't mean any disrespect here whatsoever. It was the first time that I've seen poetry used in founding papers. Perhaps I just haven't read enough founding papers yet. So that was unfortunately dismissed in the Western Cape High Court last week, Wednesday, if I recall correctly. So unfortunately, hairdressers are, as per the Alert Level 3 regulation, still not able to operate. That's not meant to be an expression of my view on whether or not hairdressers are or should be allowed to trade. It's just an interesting bit of news from the last week on legal challenges. I think if I look at the 2 Democratic Alliance challenges, the first one, which was brought in the North Gauteng High Court, was really quite specific to Alert Level 4. They took issue broadly with 3 issues. And that was the curfew that was imposed. They also took issue with the fact that the exercise regulations prohibited exercise outside of the 6 to 9 a.m. Time period. And then finally, they took issue with the fact that more e-commerce was not opened up. So I think that one is largely moot now, with Alert Level 3 having been announced. However, the Democratic Alliance has a second challenge, one which is a little bit or a lot more wide-ranging. In that challenge, they've cited the Speaker of the National Assembly, the Minister Nkosazana Dlamini Zuma, the National Council of Provinces, the President, and essentially they've taken issue with the fact that Section 27 of the Disaster Management Act seems to have delegated the President's powers. They take issue with the constitutionality of the state of emergency, and the distinction between a state of emergency and a state of disaster. So, as you know, if a state of emergency had been declared, then Parliament would have a very important oversight role. What happened with the declaration of a disaster as opposed to a state of emergency is that, and as the DA argues, is that Parliament's oversight role has essentially been surpassed. And they take issue with the fact that Parliament is essentially prohibited from performing its oversight duties over the Cabinet during this time. So that one, I believe on Friday the 29th, they achieved a very small victory in that the Constitutional Court said that it would hear arguments on direct access. So we will see that challenge go ahead in the Con Court. That challenge was also filed in the North Gauteng High Court, but it'll be a very interesting one to watch over the next few days. The 2 challenges which I found very interesting, the one I think the media seems to be referring to it as the Progress Challenge. Essentially, it's the applicants in that matter are UCT students. There are media personnel, and they have taken on really the formation and the structure of the National Command Council, if I'm getting that right. I'm not sure I am. but what I found quite interesting there, if I can just pull these papers up. So the challenge there, which has been quite interesting, is that they are challenging the formation of the National Command Council, and then very specific parts of the regulation. So they take aim at the movement regulations, so that's 16.1 to 16.4, and then the opening operation of economic sectors. I found that challenge to be quite inspired. A lot of what is set out in the founding papers, I think, is what, the arguments that I would like to make against the lockdown. Those are the papers that I mentioned are 355 pages long. So it's probably not going to be a page turner for a lot of you at home. For attorneys like me, I found it very, very interesting.
You're such a nerd.
From Lucien, of all people.
Hot kettle.
So yeah, and then the other challenge which I thought I'd pay a little bit closer attention to in the very short time period that we have is the Helen Suzman Foundation. She has cited similar parties to the DA's challenge and the the Progress challenge, and I think this is, if not the strongest, then definitely one of the two strongest challenges that we'll see during this time. They've taken issue, very broadly speaking, with the various infringements of the separation of powers doctrine that we've seen. So they've focused on the fact that essentially the president has failed to pass legislation regulating the effects of the COVID-19 crisis, and that the president and cabinet, that parliament and cabinet have failed to exercise their oversight role over what's been going on. So this challenge essentially, if we look at the separation of powers doctrine, and I'm going to try and explain this very, very briefly. Parliament does legislation, the cabinet, the executive authority is the administrative arm of government, the judiciary is the judges and our courts. Now, what we have here in effect is that Minister Dlamini Zuma, as the minister designated in terms of Section 3 of the Disaster Management Act, is making regulations in terms of Section 27. So essentially, she's acting as somewhat of a legislative body, and it's essentially cabinet is now making laws. And if you tie these issues into some of the issues that are raised in the other challenges, we don't have Parliament overseeing this lawmaking role, and we don't have Parliament overseeing cabinet, which would usually happen if this was a state of emergency as opposed to a state of disaster. I don't know, given the time, if we can go any deeper into those cases, but I will just say that the Helen Suzman application, I think, is set down to proceed on the 15th of June, and that is in the Constitutional Court. It's also one that I'm going to be watching quite closely.
Matthew, can I interrupt you there quickly?
Yeah.
Sorry. No, so I find the Helen Suzman application quite interesting. I haven't looked at the papers, obviously, so so I'm not in the best position to comment on it. But I do find it interesting that an argument has been made that because of the choice of law that was used to rely on, the executive has evaded the scrutiny of the legislative arm of government, in other words, Parliament. So had they gone by declaring a state of emergency rather than a national state of disaster, they would then have to report to Parliament regularly, and Parliament would have the oversight issue with them, and Parliament could take them to task.
And Parliament would have had to approve that declaration of an emergency as well.
Exactly. So I just quickly went to Section 37 of the Constitution, and it says a state of emergency may be declared only in terms of an act of Parliament and only when the life of the nation is threatened by war, invasion, general insurrection, disorder, natural disaster, or other public emergency, and the declaration is necessary to restore peace and order. So I think that I suppose one could argue, sorry, and I'm formulating my argument as I'm speaking here, but I suppose one can argue that the basis for saying that the pandemic requires a state of emergency to be declared is because the life of the nation is threatened by a natural disaster or another public emergency. And the declaration is necessary to restore peace and order. Yeah, sorry, do you want to?
So I actually highlighted
these. Me about that.
I highlighted these paragraphs because I think it's highly relevant to a few of the challenges that we're seeing. So reading from paragraph 13 of the Helen Suzman Foundation's challenge, as is the founding affidavit, it states as follows: the HSF's case is uncomplicated. The Disaster Act, which redirects in a wholesale way legislative and executive power to the minister, can only operate for a very short period, namely until Parliament and Cabinet are positioned to reclaim their primary constitutionally mandated legislative and executive roles. So I think it's critical here to note that, first of all, the Disaster Management Act has never been tested before. I think this would have been sort of,
I think it has been. No, I think it has been with a draft. I think
it has been under the draft,
yeah.
but not nearly on a national scale, and certainly not with the impact on people's everyday lives as much as now. So I think when this first got drafted, that was back in 2003 and 2004 when it became effective. I don't think it would have been scrutinized too closely. And now that it's affecting everyone's lives, obviously we're all unpacking it in minute detail. But it seems as though the legislature intended for it to operate as a stopgap for a very short period. And that's a large thrust of the HSF's challenge. And it says here that, and I continue reading from that challenge, it is evident that Parliament and the National Executive believe that the Minister can exercise her power for as long as COVID-19 presents a threat. This could be for months or even years, meaning that the state's response to COVID-19 will remain exclusively within the subjective purview of the executive branch of government. What the HSF seeks, in other words, is simply the return of power to Parliament and the executive functioning as required by the Constitution. I think a lot of the challenge there is based on the fact that, yes, the Disaster Management Act does enable the minister to take urgent steps. We've seen that happen. She took the steps essentially in March. I think on 18th of March, the state of disaster was declared. We are now in June, staring down the barrel of what could be a month, 6 months to longer lockdown, which might be with us for quite some time. So what the HSF is saying is that if you needed to do something in the very short term to fix the problem or to deal with an emergency, that's fine. You've done it. You've bought yourself, 2 or 3 months. Now we need to see the return to power of the constitutional bodies, which are usually entrusted with making laws and overseeing cabinet, which we don't have at the moment. At the moment, Parliament is not exercising its oversight role.
One may argue that given the way that the virus has attacked and the requirement for a speedy response, that it's actually better to invoke a national disaster because it allows for a quick and decisive response. Whereas if you've declared state of emergency, requiring a parliamentary approval, and as we know, Parliament is going to differ on various issues and it's going to be hard to pass, you may end up having the virus do so much more damage because of the ineffectiveness of Parliament to make laws quickly and respond quickly. Again, this is not my area of expertise. I'm just sort of spitballing here right now, but I would think that may be an argument. And if you look at the definition of a disaster in terms of the DMA, it's actually falls. It seems like this is a lot more relevant. The DMA is a lot more relevant for this kind of disaster than the Constitution dealing with the state of emergency. A disaster is described as a progressive or sudden, widespread or localized, natural or human-caused occurrence which causes or threatens to cause death, injury, or disease, and a significant or damage to property which isn't relevant, or significant disruption of the life of a community. and it is of a magnitude that exceeds the ability of those affected by the disaster to cope with its effects using only their own resources. So it seems to be a lot more focused on what we're dealing with right now. But of course, the argument could be raised that the state of emergency is allowed in terms of the Constitution. This act is not the Constitution. And people may say, given the separation of powers as enshrined in the Constitution, that this takes away the power of the legislative body, which gets its power through the Constitution to make laws. And therefore the DMA, or the Disaster Management Act in of itself, is unconstitutional. I'm cognizant of the fact that it's 6 o'clock and we're on our most, we're as late as we can go. Does anybody have, maybe Matthew, if you've got some closing remarks to that, and then I'll maybe go through Peter and Megan as well afterwards, before we close up for the evening.
Yeah, so points in rebuttal. Thank you, Lucien. I think just very briefly, I think that, as I said earlier, the Disaster Management Act probably was the appropriate tool at the time. You know, it looked like you had this uncertain threat coming from China. We'd seen places like Milan in Italy and New York in the United States, which really suffered massive human loss of life in a very short period of time. So in March, this made sense. It's now been March, April, May, and we're going into June. So I think, as I said, the Disaster Management Act was probably the appropriate tool at the time to buy some time. But now we've seen this seemingly endless series of extended alert levels brought in. We're currently at alert level 3. We're not sure what alert level 2 looks like or when it will come into effect. And some areas might go up, others can go down. So the state of emergency, sorry, the national state of disaster is scheduled to end on the 18th of June, but that is subject to extension by the minister. So I think without Parliament's effective oversight role, the 18th of June is 2 and a bit weeks from now, which means the minister might well decide without the oversight of Parliament to extend this for another 3-month period. And then we sit with a 6-month period where the National Assembly has not been able to exercise its oversight role over cabinet or have any say in the rights that are being limited. So that's a very serious issue. And then one last bit that I'll just end on, and that's the critical role that multi-party democracy plays in our constitution and our democracy. The cabinet is essentially, barring one minister, if I remember correctly, all ANC representatives, whereas the National Assembly, as you know, is made up of multiple parties. So in the National Assembly, we have the ability for other smaller political parties to exercise oversight and to raise issues of importance for their own constituencies, whereas for such time as the cabinet and the executive and the NCC are in control of the lockdown period, it's really only one party that is able to sort of dictate what is happening. So I'm all for more oversight and more of an active role from Parliament, and I'll end things there.
Peter, do you have anything to say?
Nothing at this stage. Thank you, Matt. Yeah, so definitely agree. No,
I think Megan? just in terms of like going down a level, it's going to be another round of regulations being issued by ministers that are going to change a lot of things. So keeping up to date with those things. So exactly how alert level 4 seemed to have rolled out with general regulations, and then the ministers came up with their regulations. That's what's going to happen for alert level 3 as well. So just to keep up with those.
Yeah. Thank you very much, everybody. Thank you also to the attendees, all of you who've been listening and putting in questions, and also just thinking about what I hope we've managed to keep you engaged and listening and interested. We will again be doing another one of these within the next week, I think, probably next week sometime. So please keep an eye out for our next webinar, and thank you for joining. Have a good evening, everybody.
Okay.
Yes, Matthew.
Good evening.
Okay. Thanks. Cheers. Bye-bye.